Before you scroll, consider this. While most of the country was asleep, 6 justices made a decision. In a matter of hours that rewrote the rules for millions of lives. No full hearing, no long debate, just an emergency order. And when people woke up, everything had changed. This story doesn't begin in a courtroom packed with cameras. It begins quietly, almost invisibly, on what's known as the Supreme Court's emergency docket. A place most Americans never think about. A place that used to be rare, technical, and boring. And now, a place where some of the most powerful decisions in the country are made at lightning speed. The 6-3 emergency ruling we're talking about didn't arrive after months of arguments or careful public explanation. It landed suddenly, and the effects didn't stay contained to lawyers or politicians. They rippled outward, touching workers, families, businesses, states, and entire industries too. To understand why this matters so much, you have to understand what an emergency ruling really is. Traditionally, emergency orders were meant for true emergencies. Things like stopping an execution hours before it happens or freezing a lower court decision temporarily to prevent irreversible harm. They were supposed to pause the system, not reshape it. But over the last few years, something changed. Emergency rulings stopped being pauses and started becoming final answers. Short orders began carrying massive consequences. And this 6-3 decision is one of the clearest examples of that shift. The first thing that shocked legal observers wasn't just the outcome. It was the speed. A lower court issues a ruling. One side rushes to the Supreme Court, and instead of waiting for full briefing oral arguments and a detailed opinion, the court steps in almost immediately. A few pages, sometimes just paragraphs, little explanation, no signatures attached to the majority, and yet the result is binding, immediate, real. Overnight, policies change, payments restart or stop, rules apply or vanish, and millions of people are left trying to understand what just happened. Now, here's where the 6-3 split becomes critical. A split like that tells you this wasn't a technicality. This wasn't everyone agreeing on a narrow procedural issue. This was ideological. 6 justices saw the law, power, and urgency one way. 3 saw it another way. And when the court divides like that in an emergency setting, it sends a signal far beyond the case itself. It tells regulators, lawmakers, corporations, and investors something very important. It tells them how far this court is willing to go, how fast it's willing to move, and whose arguments carry the most weight when time is used as a weapon. For millions of people, the impact wasn't theoretical. It showed up in bank accounts, in letters from employers, in notices from government agencies. Some people suddenly owed money they thought was paused. Others lost protections they believed were settled. Some states had to scramble overnight to rewrite rules. Businesses had to adjust compliance strategies with no transition period. This is what emergency power looks like when it's no longer rare. It doesn't give you time to prepare. It forces you to react. What makes this even more unsettling is how invisible the process is to the average person. Congress debates in public. Presidents sign laws on camera. Markets move in real time. But emergency Supreme Court rulings often arrive late at night, buried in legal language, reported the next morning as a headline without context. Most people never read the order. They just feel the consequence. And by the time they ask why, the answer is already locked in from a financial and economic perspective. This matters more than most people realize. Markets hate uncertainty. Planning depends on stability. When rules can flip overnight through emergency orders, risk calculations change. Lenders adjust terms. Employers delay hiring. States hesitate to launch programs. Investors price in legal volatility. This is not just about law. It's about confidence. And confidence is the foundation of every modern economy. There's also a deeper structural issue at play. Emergency rulings used to be the exception. Now they're becoming a parallel system of decision-making. A fast lane where monumental questions get resolved without the same transparency or accountability as normal cases. Supporters argue this is necessary in a fast-moving world. Critics warn it concentrates too much power in too few hands, with too little explanation. And when that power consistently breaks along a 6-3 line, people start to see patterns instead of principles. The people most affected by this ruling didn't get a chance to be heard. No amicus briefs weighed carefully over months. No oral arguments broadcast to the public. No long opinion explaining the reasoning in plain English. Just a result. And that result reshaped their reality. That's why this decision feels different. Not just because of what it did, but because of how it did it. This is the new Supreme Court reality. Fast decision, high stakes, minimal explanation, and a growing reliance on emergency authority to settle questions that used to take years. Whether you agree with the outcome or not, the process itself should make you pause. Because once a court learns it can move this fast, it rarely chooses to slow down. Again, and the most important question isn't what this ruling changed yesterday. It's what it makes possible tomorrow. Because if 6 justices can alter the lives of millions through an emergency order once, they can do it again. And again. And the next time, it could be an issue you didn't expect, affecting people who never saw it coming, starting right now. Imagine what this does to the balance of power going forward. When an emergency ruling carries the same real-world weight as a full Supreme Court decision, every major legal battle changes pay. Lawyers no longer just argue about who is right, they argue about who can move fastest, who can frame an issue as urgent enough to trigger emergency intervention, who can reach the court first. Speed becomes strategy. And when speed becomes strategy, the system quietly tilts in favor of those with resources, coordination, and access. This is why this 6-3 emergency ruling sent shockwaves through legal, political, and financial circles. It wasn't just a one-off outcome. It was a signal. A signal that if you lose in the lower courts, you might not have to wait. A signal that emergency relief is no longer rare. And a signal that the Supreme Court is increasingly comfortable deciding massive issues without the full traditional process. That changes incentives everywhere else in the system. Think about what that means for state governments. When states pass laws or implement programs, they usually assume some level of legal runway. Time to adjust. Time to respond to court challenges. Time to plan budgets and enforcement. An emergency ruling wipes that runway out overnight. A state can find its policy frozen or overturned before it even fully takes effect. That uncertainty forces states to be more cautious, or in some cases, more aggressive, pushing legal boundaries quickly before the court steps in again. Now zoom out to businesses and employers. Compliance is expensive. Planning is slow. Contracts are written based on existing rules. An emergency ruling can instantly change hose rules, leaving companies scrambling. Do you change payroll systems immediately? Do you pause hiring? Do you revise benefits or pricing? Every hour matters. And when rulings come without detailed guidance, companies are forced to guess how far the decision goes. Guess wrong, and you face lawsuits or penalties. Guess too conservatively, and you lose competitiveness. For ordinary people, the experience is even more disorienting. One day, you believe something is paused, protected, or settled. The next day, it isn't. There's no warning email from the Supreme Court, no countdown clock, just a headline and a deadline. And because emergency rulings often lack detailed explanations, people struggle to understand their options. Do you owe money again? Are you suddenly out of compliance? Do you need to act now, or can you wait? That confusion is not accidental. It's the natural result of speed replacing deliberation. What makes this particular ruling even more consequential is how clearly it followed ideological lines. A 6-3 split tells the country something about predictability. Not certainty, but predictability. It tells future litigants which arguments are likely to land and which are likely to fail when time pressure is involved. That predictability shapes behavior. It encourages more emergency appeals. It increases the number of high-stakes cases reaching the court through the fastest possible route. And over time, that reshapes the court's role from referee to first respond. There's also a trust issue here. Courts derive legitimacy not from force, but from public confidence. People accept decisions they dislike because they believe the process was fair, thorough, and principled. Emergency rulings strain that trust. When life-altering outcomes arrive with little explanation, people don't just question the decision. They question the system. They wonder who is really being heard and who is being bypassed. That skepticism doesn't stay confined to one case. It spreads. From a financial markets perspective, this erosion of predictability matters deeply. Markets can handle bad news. What they can't handle is sudden rule changes without warning. Emergency rulings inject legal volatility into economic planning. Analysts start adding legal risk premiums. Investors hesitate. Long-term projects slow down. When the rules of the game feel unstable, capital becomes cautious. And cautious capital means slower growth. Supporters of this approach argue that speed is necessary in a world where harm can happen quickly. They say waiting months or years can itself be unjust. And sometimes they're right. Real emergencies do exist. But the concern is scope creep. When everything becomes an emergency, nothing truly is. The extraordinary becomes ordinary. And with that shift, the safeguards designed to protect fairness quietly weaken. This ruling also raises a deeper constitutional question. Who decides what counts as urgent? The court itself? There's no external CK, no requirement for full explanation. No formal standard that must be met in public. That concentration of discretion is powerful. And power, once exercised, tends to expand. Not necessarily out of malice, but out of habit. The long-term impact of this decision won't be measured only in court citations. It will be measured in behavior. How aggressively governments push policies. How quickly corporations respond to legal threats. How often lawyers rush to the emergency docket. And how much faith ordinary people place in a system that can change their lives overnight without asking them to listen first. And that brings us to the most uncomfortable realization of all. This ruling didn't just change outcomes, it changed expectations. It taught everyone watching that the fastest path to the highest court might now be the most powerful one. And once that lesson is learned, the system itself begins to move differently, faster, and with far less room for reflection than ever before. The country has time to absorb what's happening. That's the real shift. Not just legal, psychological, institutional. The Supreme Court is no longer perceived only as a slow, deliberate body that settles disputes after years of careful consideration. It is now also seen as an active force that can intervene instantly, decisively, and with consequence that ripple through everyday life. This changes how power is exercised across the entire system. Lawmakers start drafting bills with emergency litigation in mind. Agencies design regulations knowing they could be halted overnight. Advocacy groups time lawsuits strategically, racing against implementation dates instead of focusing on long-term persuasion. Even judges in lower courts feel the pressure, aware that their rulings might be frozen or overridden before the ink is dry. The entire ecosystem accelerates, and when systems accelerate too fast, mistakes become more costly. Nuance disappears. Gray areas harden into absolutes. Emergency rulings don't leave much room for adjustment. They don't invite compromise. They draw a line and enforce it immediately. For some, that line brings relief. For others, it brings disruption. But for everyone, it brings a new sense of fragility. The sense that stability is provisional, dependent not just on law, but on timing. This is why millions felt the impact of this 6-3 ruling even if they couldn't explain it. They felt it in deadlines that suddenly mattered again, in protections that quietly vanished, in obligations that returned without warning. And when people experience that kind of whiplash, they don't just respond to the specific issue. They adjust their behavior going forward. They become more cautious, more defensive, less trusting. In finance, that mindset has consequences. Households delay decisions. Businesses hold cash. Governments hesitate to commit. The cost of uncertainty is rarely visible on paper, but it's always real. It shows up in slower growth, missed opportunities, and rising anxiety. And when legal uncertainty becomes systemic, it acts like friction in an engine. Everything still moves, but not as smoothly, not as confidently. What makes this moment especially important is that it sets a precedent without fully acknowledging it. Emergency rulings don't come with sweeping language about changing doctrine. They don't announce new eras. They simply act. And in doing so, they normalize behavior that would have seemed extraordinary a generation ago. Over time, those actions redefine what is considered normal judicial power. Some will argue this is just adaptation, that institutions must evolve to meet modern challenges. And there's truth in that, but evolution without transparency carries risks. When decisions speed up faster than public understanding, trust erodes. People begin to feel governed by outcomes rather than principles, by power rather than process. The 6-3 split matters here because it underscores that this is not a neutral evolution. It reflects values, priorities, and interpretations of authority. It tells us how this court views its role in moments of urgency. And as long as that composition remains, those signals will continue to shape behavior far beyond any single case. So where does that leave the country? In a place of heightened awareness. The Supreme Court is no longer something that only law students and journalists watch closely. Its emergency docket has become a lever that can move real lives in real time. And once people recognize that, they start paying attention not just to final decisions, but to timing, procedure, and silence. The silence matters. Because what the court doesn't explain leaves room for speculation, fear, and misinterpretation. And in the absence of clarity, people fill the gaps themselves. That's how narratives form. That's how divisions deepen. And that's how confidence quietly drains away. This 6-3 emergency ruling will be remembered not only for what it decided, but for what it revealed. It revealed a court willing to act fast, wield enormous power, and accept the consequences of speed over deliberation. It revealed a system where urgency can override tradition, and where millions can be affected before they even know a decision is coming. Whether you see that as necessary progress or dangerous overreach depends on your values. But one thing is undeniable. The rules of the game have changed. And in a world where decisions can arrive overnight and reshape lives, by morning, understanding how power moves is no longer optional. It's essential.